Oh, brother, was this a dandy? Let's take a look at this professional responsibility essay. Trigger warning, you're not going to like it. This is one of the weirdest ones I've seen, so let's watch this car wreck in real time. Okay, let's take it from the top. We'll go to the calls to the question first. Number one, what ethical violations, if any, has Rex committed? And what ethical violations, if any, has Nancy committed? And because they're asking about ethical violations, that's the examiner's way of saying, hey, we're testing professional responsibility. So use that as a cue. And then at the end, it says answer according to California, both California and ABA authorities, which is a clear indication the examiners are testing entirely with professional responsibility. Now, I'm going to read this one to you with my actual notes, which will be included in the description or in the chat below, so you'll be able to access it with the model answer that I put together. It's tentative, by the way. So let's take a look from the top. While attending law school, Rex worked as a real estate broker, which is going to be relevant later because it goes to whether or not he's a specialist. And he was a co-owner of Realty Co., a real estate brokerage firm. Rex sold his interest in the real estate company when he passed the California bar. If one knows, Rex was one of my students. He took one-timers. So Rex is a solo practitioner who represents buyers of real estate. Keep in mind, these facts specifically state Rex is a solo practitioner. So later, he cannot represent that he works with associates or runs a big law firm. During the last year and a half, and it's interesting, I almost didn't catch this one, and I'm sure a lot of you didn't. California has this really weird rule that has never been tested in the history of the exam, as far as I know, and I've only gone back to the 70s, not to the 20s or 30s. But in California, if 3 or more malpractice suits have been filed against you within a 12-month period, you must report it to the state bar. But here, these were within a year and a half. So maybe it was 2 in the first 9 months, and the other 2 were in months 13 and 15. I'm sorry. Yeah, that'd be right. So it isn't clear if the 3 suits were filed within a single 12-month period, which means there is no reporting violation. But even if you didn't spot that or you didn't know that obscure rule, that's part of the Business and Profession Code 6068, always an open number 1. Yeah, most people didn't know that. If you did, good for you. So Rex has been sued 4 times. Rex has not told anyone about being sued for malpractice because there have been no judgments against him. It doesn't matter because the reporting rule is triggered by the filing of the suits. So the absence of any judgments and Rex's belief that they are frivolous does not excuse reporting, provided they would have been within that 12-month period, which is unclear on the facts. We're a wicked fact pattern. He believes them to be frivolous. Now, here's the actual rule. It's a California rule, not an ABA rule. An attorney must report to the state bar within 30 days if 3 or more lawsuits for malpractice have been filed within a 12-month period. Okay, next paragraph. Wow, that was a tough opener. I'll tell you that much. And if you just felt like your car went off the cliff, I'm with you. So I think a lot of people are going to be very disappointed in their grade on this essay. And that's not to discourage you. It's just to let you know, buckle up. To help Rex get clients, his former partner at Realty Code allowed Rex to place a sign in the lobby. Okay, so attorneys may advertise the services so long as it's not false and misleading. I mean, after the 70s and that Supreme Court case about the First Amendment, lawyer advertising is commercial advertisement. So it gets, believe it or not, intermediate scrutiny, although you don't need to know that for here, but if you see it in con law in the upcoming bar or in law school, just so you know, commercial speech, which is part of lawyer advertisement, gets intermediate scrutiny. All right, and notice it's free of charge. So Rex is not paying or giving his former partner anything of value for the recommendation or the advertisement. So there's no violation here because it's free of charge. And I think that's why they put it in there, interestingly enough. Again, I can't begin to advocate and stress how important it is to really pay attention to the facts. The examiners don't go out of their way to use certain facts, especially descriptive language, dates, numbers, amounts, unless they're trying to draw attention to it. So pay attention. Reading carefully is one of the biggest things on the exam. The sign advertises as follows. So whatever means are used to make known a lawyer's services, they must be truthful. Looking for a state bar certified real estate attorney. So the lawyer may not state that he is certified as a specialist unless that certification has been by the state bar or an accredited organization, and you must also clearly identify and list the organization's name in the communication, like which which body, accredited body, or which state bar has made you or certified you as a specialist. So this is a violation because even though it seems like he could probably qualify as a specialist based on his experience in his past, he hasn't been certified yet. And California doesn't even include real estate attorneys in their certified specialist list. Did you know that? I didn't. Be honest with you, like I look like an expert after the fact, but going into it, I didn't know that. Call Rex Jones and Associates. So, all advertisements must include the name and contact information of at least one lawyer responsible for its comment. That's under the ABA. California is a little more anal on the matter. They require not only the name, but an address. By the way, for ABA, a website's fine. The business location's fine. And notice it says and associates. Well, this is misleading because it implies that Rex practices with other lawyers when in fact he's a solo practitioner. 1-800-BIG-FIRM. Again, that gives off the impression that this is a big real estate law firm with these certified experts and specialists when in fact it's just Rex by himself. And he seems to be pretty new. So you could bring up the duty of competence, but I'm sure that's an issue. It's almost always an issue. It's like that and the duty of loyalty. They're almost, although this one does not have any duty of loyalty problems. Anyways, here's an interesting thing. I'm really so shocked the state bar put 1-800-BIG-FIRM. I would assume they put 1-800-BIG-LAW because 1-800-BIG-LAW, as we know, doesn't have enough digits to become a real number. But here, this number belongs to Corbridge Financial that deals in like retirements. So I'm surprised the state bar used that real number. I did call Corbridge twice. I didn't get any answer, but I thought maybe hey, they could sue the state bar for doxing, right? That's an unsolicited way of putting their information out there to the public. All right, moving on. You don't need to put that. Rex recently represented a buyer at a real estate closing in California and noticed that the seller, an Arizona resident who owned only one property in California, was represented by Nancy, an attorney Rex knew to be living and licensed only in Arizona. Well, a lawyer admitted in another state and may provide legal service on a temporary basis in California, usually if they associate with a California attorney who actively participates in such matters. You'd know that as pro hac vici. So I did that once when I did a trial in Utah. I actually associated with co-counsel, actually one of my law school buddies, and we did the trial together, and we got slaughtered. But it was still fun. It was a great experience. Guilty on all 4 charges, by the way, for our client. But then again, he really was guilty. In casual conversation, Nancy told Rex that she is temporarily representing her client in California in the real estate transaction. Now, here's an interesting rule, one that I have not seen tested in the last quarter of a century or longer. Over 20, actually 30, 40 years, I haven't seen anything like this tested. So this is why I thought this essay was so obscure, because it's pulling out things that, I mean, you're dusting them off. They're like artifacts, stuff that never gets tested. So I'm wondering what crawled up there, and decided, hey, let's just test this obscure things and give students a heart attack. So, by the way, when I did the civil procedure essay for the 2026 February exam and I did the UCC one, I said those were walks in the park. Some of you may roll your eyes and go, he says that about everything. No, I don't. This one was a son of a bitch. I didn't like this one. I think this one was one of the most difficult PR essays I have seen. And that is me being straight with you. I'm always going to be honest with you. And I'm giving my honest opinion based on everything I've ever seen. Okay. One, that Nancy may provide legal services on a temporary basis, so long as they are reasonably related to her practice in Arizona, which it seems like it is. She may have that little out right there, even though she's not associated with another attorney. However, when you read the rule, it says, it's got C as in Charlie, it's got 1, 2, 3, or 4. Does that mean 1 is 1 and 4, or 1, 2, or 3? It's just the way I was reading it. I don't know if that's 100% right, but all the research I did confirm that I think this is accurate. Correct me if I'm wrong. Let me know in the comments. Say something. Hit me up. You can always call me. You can always email me. Pretty easy to find. Call the 800 number for one-timers. Call my cell phone. Email me if you want to talk about this essay, even if you're not one of my students. It's totally fine. I actually enjoy this stuff. I'm sick in the head because I love it and I do it all day long. Rex researched Nancy and discovered Nancy was previously disbarred in Arizona, but now she's in good standing. So I'm not quite sure what they're getting at, because if she was disbarred, he'd probably have to report it. And also the fact that she's practicing law in California without a license, which is a misdemeanor under the California Professions Code. So that means he would have a duty to report her if he knows that she's unlicensed in Arizona, in California. However, that temporary one, that kind of throws a little monkey wrench into the mix, and I'm not quite sure how that would get handled. Anyways, this last paragraph about she's in good standing with the bar. I'm not quite sure what the examiner is getting at here, but I believe there's some kind of notice requirement to the client or some type of California ban that actually deals with California Rules of Court 9.48. You might want to look that up, 9.49. But they're not, we don't follow California Rules of Court for this exam, so I didn't include it. I guess we'll have to see what the selected answers say. Anyways, that is my conclusion. That is what's going on here. Yes, my answer, which is going to be included in this with this video, doesn't talk about the duty of competence, which is an issue that can be brought up at any time. Clearly, Rex is competent to do this. Nancy seems competent as well, I assume. But anyways, that's always a kind of a throwaway issue. So whether or not the examiners are really looking for it is anyone's guess. But, you know, put it in there. What the heck? Okie dokie. That's it. That's my analysis. Look forward to speaking to you. Comments, questions, let me know. Thanks for watching.